Good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. This is July 22nd, the jail calendar. I'm going to call the calendar. I'll probably call the arraignment calendar first because I believe that that will probably be shorter. I'll address the arraignment calendar and then we'll address the jail calendar.
We don't have a record today, Judge.
Just one. Okay. All right. So the first case on the jail calendar is Blankumsey, Solomon Blankumsey. That's going to be a petition.
Yes, Your Honor. I noticed that he had a private attorney, so I would have a case before his was revoked. So I would have to speak to him in regards to whether he won our representation and then go from there.
Okay. Let us know.
Yes, ma'am.
All right. Raekwon Lamar Monte Dixon. This is a motion to modify sentence.
Yes, Judge. I did file that motion and I am prepared to go forward.
All right. You all couldn't consent?
Well, I had assumed that Your Honor would, I'm not sure if Mr. Tipton is opposing this, but I figured that Your Honor would make the final decision.
Well, how would we know if he didn't?
I have spoken to Mr. Tipton about this motion, Judge, and I didn't get the impression that it was going to be completely adversarial, but at the same time, I didn't get the impression that he was going to, I thought that asking for a hearing was the appropriate thing to do. If I certainly, if Mr. Tipton is willing to consent and Your Honor would be amenable to that, I'll certainly have that conversation with him right now.
Your Honor, state's going to defer to the court with this motion since
it's two cases. So I'm looking at one's a criminal trespass, simple battery, and the other one's a battery, family violence. So yeah, we'll go ahead and have the hearing. No problem. Chastity,
it's actually three cases.
Oh, okay. So let me go back because maybe I missed something. I did. I missed something. I went straight to that second page. Thank you, Ms. Wright. Three cases. Okay. All right. So next is Chastity Lucilla Long. Ms. Long is back.
Yes, Your Honor. I would need to have a conference with her. My understanding is there may be an MH issue here, so I will advise the court what we will do after the conference.
All right. Warren Scott Messiah.
That's a negotiated plea, Judge.
Janesia LaShawn Pope, the petition.
I would need a conference with Ms. Pope, Your Honor.
All right, Ms. Pope has two cases. Let me make sure I didn't skip one. Yeah, two cases. Michael Render.
Judge, that's going to be a negotiated plea today.
All right. Wedllo, Mr. Wedllo, Taj Wedllo.
Into my client regarding this matter, but we have not received a recommendation from probation. I'm not sure.
And I'm sorry, I did get a recommendation from Mr. Austin. He did talk to me about it. I'll tell you what that is. I'm sorry.
Thank you.
And last case is Wilcox. Andrew Lee Wilcox.
Judge, this is a case where there's some serious concerns about Mr. Wilcox's stability, and I think we're going to conference with the state. I know that he's not up yet. I think there were some safety issues, but if we could just have a conference with the state, we may have an announcement as to which way we're going to go with that.
All right, so let's hear the motion right now. That way we can take care of Mr. Dixon, and then I'll allow you all to conference and we'll come back and take all of the rest of the petitions and pleas.
Absolutely, Judge. If I could just have one moment.
Okay.
We're going to need Mr. Dixon out here in a moment. Let me just pull up something. He wants 6 months to serve. Pretty much do everything right here because the mic, you know, can't really pick people up over here. Yeah, I wish it was. Yeah, you can sit right here. Yeah, they can hear us. We're just waiting for the judge to come back.
All right, are we ready for the hearing?
We are, Your Honor.
All right, so this is the matter of State of Georgia versus Raquan Lamar Monte Dixon. Mr. Dixon is before the court on 2024 CR 02178, also on case 2025 CR 00537, also on case 2025 CR 00546. And this is a motion to modify sentence brought by his attorney, Mr. Owen Lynch. Mr. Lynch, go ahead, sir.
So Judge, I am asking you to modify his sentence pursuant to this court's authority and jurisdiction under 1710-1. And so, and I understand it's in the court's discretion. Mr. Dixon did enter into a negotiated plea to resolve the 3 cases that you read off, and the sentence was a 1 year to serve concurrent on all cases. Judge, Mr. Dixon has been continuously incarcerated since November 19th, I believe, or that may have been his first appearance, but at the end of November of 2024. So he has Clayton County since that time. So I believe he's been in there for about 8 months, Judge, and he was in custody on these cases. So I believe that that is the time that he served so far. And we would certainly ask that he be credited for that time. Judge, a little bit about Mr. Dixon. So Mr. Dixon is 26 years old. He does not have a GED, but he does wish to obtain one. He has 3 children, 3 sons, Jeremiah, Messiah, and Josiah, ages 5, 4, and 3. Those children are not in his custody, obviously. They're not children that he shares with the alleged victim in our cases, but he is actively involved in their financial support, and he does have a good relationship where he is co-parenting with the child's mother, with the children's mother. Prior to being incarcerated, he has found a way to to be actively employed. He's worked in the construction industry. He's had several. He also engaged in tattooing. Judge, what we're asking the court to consider in this case is 2 things, really. If you would consider probating the remainder of the year to allow him to enroll in either a family violence intervention program along with the GED program, or Your Honor may note that with the time remaining on the sentence, family violence intervention program may not be able to be completed in that time. But Judge, I would, for the court's information, Mr. Dixon will be under supervision of the Superior Court. He is on probation, and Judge, that is with a case involving the same victim in this matter, Judge. And so we're not here to discount or minimize any of the offenses that Mr. Dixon has entered into pleas. I would note that the entirety of his criminal history with regards to anything more serious than a traffic ticket has come out of this relationship, Judge, and Mr. Dixon has moved on. Miss Jones, I believe, has also moved on. Excuse me. So he is 26 years old, but the relationship started when he was much younger, Judge. I think that Mr. Dixon does want to get on a path. I'm going to let him speak as well, but does want to get onto a path to put himself in a better position to provide for his children. And I think that it's not too late for Dixon to turn his life around, that him enrolling in a family violence intervention program or anger management, enrolling in a GED would better serve the interests of the community for Mr. Dixon. Mr. Dixon certainly takes responsibility for what he has done, and he has been in the Clayton County Jail for a long period of time, and that experience has certainly opened up Mr. Dixon's eyes to the consequences of engaging in criminal behavior or putting himself in a situation where criminal charges are brought. And so, Judge, I'm asking you to consider either probating the remainder of his sentence with any conditions the court thinks are appropriate, whether that's GED, enroll in family violence intervention program, or, Your Honor, if that does not strike the court as an appropriate modification, that is our main, what we would really like the court to do. However, if Your Honor were to not want to go that route, if you would consider giving him a release date and allowing him to serve the remainder of his sentence on weekends, Judge, so that he can start enrolling in or start getting himself employed so that he can provide for his children, and working towards that GED, which he did tell me he wants to do regardless of whether it's ordered by the court. So that is where we are with that. That's essentially my motion, Judge. And if you would like to, well, that's the motion, Judge.
Mr. Tipton?
Your Honor, at this time, I'm going to defer to the court. It looks like Mr. Did plea under first offender in Superior Court to a separate battery, family violence, and a criminal damage to property in the second degree against the same victim in our cases. I believe Your Honor had imposed the 12 months to serve based on the voluminous amount of cases that he had pending before Your Honor. At this point, Your Honor, state defers.
So Mr. Dixon, you are 26 years old, sir, and you have several cases with the same victim. Now, Mr. Lynch has been with me long enough to know that I don't hand out 12-month sentences just willy-nilly. In fact, you're probably only the second or third person to get a full 12-month sentence. So because I don't think that jail is the best thing for, I mean, most misdemeanor cases, jail is not where progress is made. However, I just don't get how somehow you couldn't figure out from the first case, the second case, the third case. You got 2 upstairs and you got 3 with me. How you couldn't figure out that continuing to have violent contact with the mother of your children was not a smart idea.
And Judge, I don't want to.
Sorry, go ahead.
Not to correct the court, Judge.
Uh-huh.
This is not the mother of his children, but I understand that's not necessarily changing your
So
point.
who is the mother of his children? Not the victim in these 3 cases?
No, ma'am.
Yeah, Mr. Dixon, this is a hard one for me because I did this with intention. I gave you 12 months with intention. I'm not sure why we are here now asking to have this shortened because you haven't, I don't know what changes you made in the time you've been in jail that would inspire me to say, well, yeah, get out of jail now. Um, you had 26 years, you had from the time you were 18 to 26 to get a GED or to go back to school or to find some way to better yourself. And you didn't. So now I'm supposed to believe that if I let you out for the remainder of these few months that you have left, all of a sudden you're going to be a superhero and go get your GED, go get a better job, become a better man, become a better father. I mean, for real?
I do apologize for the situation, but I did try to get my GED before, but that's when the kids came and I had to help my baby mama. So that's when I got out of the GED and started helping her.
So I'm sorry, the kids came, not
No.
that you intentionally had sex without protection and produced children, knowing that y'all probably weren't ready for them financially or emotionally.
No, we had the kids intentionally, not knowing.
Okay, go on.
But I do plan on getting my GED. I do need to be able to get out to help
See,
my.
that's what you should have done first before having all these children. You should have gotten your GED. You should have gotten a job and been stable. You should have had some health care, sick time, all of those things that come with a good job. Those things before you go out just popping out babies.
Yes, ma'am, and I was not thinking at first, but I know how to handle it now. So I do want to get my GED and be able to help my kid's mother.
So if I let you out now, you go get your GED. If I let you out, if you get out when you get out, you go get your GED. What's the difference?
Judge, I would, one difference I think would be, in addition to him being able to get the GED, he would be able to immediately start to accumulate money to support his children. And I believe that it's somewhat of a hardship, them not having that financial support.
You know what? I get that, but I don't know that I'm only hearing from him that he's a support to these children. I don't know that from the person who has the children. He's telling me, he can tell me anything, and that's all I have to go by. So most of the time it's a single parent who's doing everything. And he's trying to make it seem like he's an integral part of the financial structure of how these kids live. And I don't know that to be true, even before he went to jail. And so I just don't know that there's any incentive for me to do anything other than I did, because when you got 5 cases against and the same person is the victim in all 5 cases, I just don't think that, I mean, at some point there has to be a reckoning. There has to be, like, I shorten your sentence for what?
Well,
I mean, to get a GED, he had 7 years to do that from the time he was 18 to 26. He didn't do it, but he managed to have 3 kids. He could figure his way out around that.
And I understand the point the court's making, Judge. I would point out, Judge, that he has served significant time on this.
And
well, just that, Judge, I believe that
he
time.
beat the same woman 3 times that I know of. Then there's stuff up in Superior Court where I stay out of their business. But I now know, because y'all brought it to me, that he has stuff up there with the same woman. How stupid do I look? Maybe that woman needs this year to get her life together so she can get the heck out of Dodge and she not have to deal with him and his family.
And Judge, go ahead. What did you want me to say? Judge, I did try to get in touch with Ms. Jones. I wasn't successful in getting Ms. Jones here. But I think that you can take him at his word. You can take him at the
Yeah, I
fact.
could take him at his word, but he's not the victim. And I don't want Miss Jones to be walking down the street and she turns her head and said, that judge said he was going to be in jail for 12 months. And there's the guy who I got 5 cases against. He's standing there looking me in my face. So yeah, no. Ms. Jones would have to be part of this decision, and I'm not just gonna decide for her that she needs to turn a corner and run into Mr. Dixon before she is aware that he's out. So yeah, no, the time I sentenced him to is the time he's gonna do.
Your Honor, if I may, I just looked up Mr. Dixon's Superior Court plea. Would Your Honor like to know what his Superior Court plea is? Because even if you let him out on this, I don't think he's getting out anytime soon. It is 5 years and serve 4. So it literally reads 5 years. However, 1 year may be served on probation. So I don't think he's getting. So I think that if he is to get out of Clayton County, if he's to be released to Clayton County, I think he's just going to go to prison.
So he's just in Clayton County Jail because of my sentence?
Judge, I believe that that's incorrect. My understanding is that he served the time on the felony case and the remainder of the sentence is on probation.
If I may quote, Your Honor, on criminal damage second degree, he entered a first offender plea, sentenced 5 years. However, it is further ordered that count 1. I'm sorry, I misread that. My apologies, Your Honor. He may serve that on probation. My apologies, I misread that. Yes, Your Honor. And
yeah, well,
further,
I'm satisfied with the sentence I gave him until I hear from Ms. Jones, and I haven't heard from her to say that she is comfortable with having him out in the world again before the time that I said he would be out in the world. I'm comfortable.
And Your Honor, Ms. Jones is also part of the felony plea. He's not to have any contact whatsoever with her during those 5 years. So I assume he's probably not comfortable having contact with him.
Yeah, I'm comfortable with the sentence I gave you. Mr. Dixon, at some point, you got to to take the consequences for your actions, sir. You don't just get to harass and beat somebody to the point where there's 5 cases, and then you just decide that, well, I feel like I did enough time and I just need to get my GED, something you could have done a long time ago. That would have been a more productive use of your time than going around having three babies and beating somebody. So yes, sir. Bye.
Your Honor, if I may, you did mention that you would want to hear from Ms. Jones. Would you be willing to revisit this if I can get Ms. Jones to?
No. Because I had this conversation with somebody recently about the coercive nature of domestic violence cases. And yesterday when I was I was in court watching the trial calendar and watching people come in and out of court. And I see the person who was a defendant in the case come in with the alleged victim. Now they spent all their time sitting as far as possible from each other in the courtroom. But as soon as I saw those two people walk together, I had no clue who the victim was in that case. I had no clue it was even a battery case. But as soon as I saw something clicked in my head and I said, that shouldn't be. Let me ask some questions. So the nature of domestic violence is coercive. It is. The whole nature of it is. Because the abuser is always going to want that little edge that they can get from, well, I can get out a little earlier. I can do this. No, it's not. No, we're not doing that. Mr. Dixon, I hope you learn from this situation. Mr. Lynch says that family violence intervention program will help you, but I think at this point, you're beyond that and jail will help you. If you haven't learned in this situation to not hit people, like they say in kindergarten, don't hit people, then I don't know that I want you around your 3 kids. I don't know that I want you back in society. So yeah, sir, I'm comfortable with what I sentenced you to.
No chance I can get Your Honor to reconsider that.
Nope, nope. I've considered and reconsidered. I sat here and considered and reconsidered. And I said, you know what, Judge? You made the right decision the first time.
Thank you, Your Honor.
You're welcome. You can go back with the sheriff, Mr. Dixon. All right, so I'm gonna give y'all some time to conference. My understanding is you're conferencing on Long, Pope, Wilcox, I believe Wilcombe. You're gonna find out at Blancombe if he needs you, and Wedlow, you're gonna talk about the offer from probation, and I will be back.
Thank you, Your Honor.
Yes, ma'am. Your Honor, I know we are still doing some conferencing, but if you wanted to go ahead and take those pleas for Mr. Render and Mr. Scott, or I'm sorry, Mr. Messiah, we're ready for those if the state is.
State's ready in all cases, Your Honor.
I'm ready. Bring them up.
Bring out Mr. Warren Messiah, and then after that will be Render. I think the courtroom's down.
Raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, Your Honor.
All right, you can put your hand down, sir. You're before the court on State of Georgia versus Warren Scott Messiah, 2025 CR 06394. You're before the court for criminal trespass. Mr. Lynch, Owen Lynch is your attorney. Mr. Lynch, what does your client plead to the offense before the court?
No contest, Your Honor.
By entering a plea of nolo, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself, or and if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis and recommendation, please.
Your Honor, on June 25th of 2025, officers with the Clayton County Police Department were dispatched to 8060 Wood Lake, that's one word, Drive in Jonesboro, in regards to a domestic disturbance. There they made contact with Miss Ebony White, who stated that her ex-boyfriend, Warren Messiah, who lived at the location, gave her a time limit to evacuate the home and began punching in the wall. Let's see. White stated that the two had been staying together since March, and she allowed him to continue staying at the because he needed to stay as he had a recent stroke. The property did in fact belong to Miss White. All this did occur in Clayton County, Your Honor. The state's recommendation is 12 months to serve 27 days, credit for time served, balance suspended upon no contact, directly or indirectly, through third parties or otherwise, via any form of media, social or otherwise, with Miss White.
Okay, Mr. Lynch.
Judge, we are asking the court to accept the plea.
Okay, is there anything of his that he still needs to get with the sheriff's escort?
I believe so, Judge, and so Judge, and he understands the terms of the sentence. I believe he would need a police escort. I believe the property was Mr. Warren's, and that she was staying with him. It's the home.
Yeah.
So he's the homeowner.
Okay, is she still in the property?
He is, I believe, in order for her to leave, he'd have to inform Victor at this point if she's not willing to leave otherwise. So he understands that he has to have no contact and that.
Okay, well, sir, let me just explain the parameters of no contact. If you need to evict her through court process by going and filing for an eviction, you can do that. If the two of you need to be in court because of an eviction or other court process, that is not a violation of the no contact order.
Yes, ma'am.
Because you will not be personally serving it. It will be served by the sheriffs or marshals. So you will not have to have any contact other than showing up for a court hearing. As long as you maintain your distance from her, then that's fine. So, but I'm going to accept your plea, 12 months to serve 27 days, credit for time served, balance suspended, as long as you have no contact with Ebony White at 8060 Wood Lake, Jonesboro, Georgia. You will have one opportunity to go back with the sheriff's office to get any undisputed personal property that you need for your living for a period of time. But if you intend to evict her, I'm not talking about furniture or anything else, because the plan is for you to get back into your own house. I'm talking about things like your ID, Social Security, clothing items, that kind of thing. Okay.
Thank you, ma'am.
All right. So you will have to contact the sheriff's office. You will have to take transportation and individuals if you need help carrying things. You said you had a health issue. So if you need help with that, you have to provide all of that. All the sheriffs will do is to stand by to maintain order and peace, okay?
Thank you, ma'am.
All right, all right. So you can go back with the sheriff's office, Mr. Masai.
Render. Appreciate you.
Mr. Lynch, I know that you were waiting on Mr. Moore to potentially get on this call. Do you have an ETA on when he's going to be on?
That's not what I indicated. I said that. So let's have this conversation not in this format, sir.
Oh, my apologies. I misinterpreted you.
But I am reaching out to Mr. Moore right now.
All right, thank you.
Mr. Render, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true. All right, you can put your hand down, sir. You're before the court on State of Georgia versus Michael Render, 2022 CR 03843 for criminal trespass. You're represented by the law firm of Lister, Holton, Dennis, Mr. Olin Lynch. Mr. Lynch, what does your client plead to the offense before the court?
No contest, Your Honor.
By entering a plea of nolo to criminal trespass, Mr. Render, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On July 6, 2021, off the Clayton County Police Department responded to 2301 Mount Zion Parkway. That's the Speed Wash car wash in Morrow, Georgia, in reference to a burglary call. It was determined that the defendant before you, Mr. Michael Render, did enter onto the property without proper authority, and in doing so, did damage some of the property. Your Honor, the damaged property for our victim totaled to around $400. Because of the age of the case, the victim was not able to give us a receipt. But the state's the state's recommendation in this case, Your Honor, is 12 months to serve 10 days, credit for time served, do not return to that incident location, and $400 of restitution. This case was previously on pretrial, placed in pretrial diversion and the defendant to appear.
So just before we go forward, the $400 in restitution was not communicated through the offer. I'm not going to make an issue of that. If I could just have a moment to discuss it with my client.
All right.
My apologies, Mr. Lynch. I met with Ms. Tortorella this morning, went over all the cases.
Mr.
So
Lynch?
I believe Mr. Render doesn't have an issue paying that restitution. My only question is, it's a suspended sentence, so the restitution is going to be a condition of the suspended sentence.
We would ask that he pay it within 60 days of release.
Okay, so let me just verify whether that's going to be possible.
Can I ask a couple of questions?
Of course, Your Honor.
So I see on my calendar that Mr. Render was on a bond forfeiture calendar, which means that from the initial arraignment, he moved or something happened where we lost track of him. And that's probably likely why he's in jail, is this on a bench warrant. So if is Mr. Render stable such that he has housing and the ability to earn a living so that he can pay restitution?
No, I'm saying. Okay, so he's indicating yes. So where you staying here in Clayton County? No, sir, I'm staying in Gwinnett. Oh, Gwinnett County.
Ooh.
Where do you work at? So he's indicating he lives in Gwinnett County. He is currently employed at a bar. And he did tell me he could get that amount paid within 60 days as the state had suggested. I did suggest maybe we could see if the court would accept 90 days just to make sure. I don't know if the state would have any issue with that.
There's no issue with that.
I can do 90 days. All right, so Mr. Render, listen to me carefully, sir. So a lot of times people think because it's a business that if there's damage to a business or if they lose, it's no big deal because you know they have the ability to, they're gonna be okay. But I don't follow that pattern. I think that anytime you damage somebody, whether it's a business or an individual, then they need to be compensated for that damage. Now, the payments should be made through the solicitor's office. You can do a money order or a cashier's check, no cash. And those payments should be made within 90 days of the of today's date. Okay. So once you have finished those payments, then no problem. You won't have any problems with me. But if you fail to make those payments, then we're going to have a status hearing and you're going to come back before me and we're going to determine whether some portion of your suspended sentence should be reactivated. Okay.
Yes, ma'am.
All right. So, because you don't get to hurt people or damage people and not repair that damage. That's just not how things work. Okay. All right. So I'll accept your plea of nolo, sentence you to 12 months to serve 10 days, credit for time served. You're not to go back to the incident location. Mr. Tipton will provide Ms. Wright with the exact name and Mr. Lynch, you can verify that information. And then Mr. Tipton, you can give her the exact contact person who should receive the payments. Those payments will be made through the solicitor's office, which is on the 3rd floor of this building. And those payments should be made within 90 days. Okay.
Yes, ma'am.
Don't wait until the last minute, Mr. Render, Start putting the money aside as soon as you can. As soon as you get out and you get your first paycheck, you start putting that money to the side. Don't wait until the last minute. Do you understand?
Yeah.
All right. Thank you. You can go back to the sheriff's office.
And Your Honor, I'm sending her information to Miss right now.
Okay, thank you.
Mr. Tipton, I'm going to, if I can either call you on the Wilcox case or however you want to do that. Can I just give you a phone call?
Sure, that works.
Thank you.
All right, so y'all let me know when y'all are ready for the next stuff.
Your Honor, I think ready on Wilcox. Your Honor.
Yes, Mr. Tipton?
I believe we're ready on Wilcox. I just want to make sure we place a couple things on the record.
Okay, is this a plea?
Your Honor, it's going to be a null pros, but there's some understandings with the null pros. I just want to make sure that's on the record.
Okay, is he here? Is he up?
He may not. Good morning, Your Honor. Justin Moore, for Mr. Wilcox. Hey, Mr. Wilcox may not be up. I'm not sure. Due to his mental health condition, they often have
Okay.
some issues with him.
All right, so who's representing Mr. Wilcox?
I will be, Your Honor.
Okay, we're ready to go forward then?
Yes, ma'am.
Go ahead. So this is 2025 CR 05427, Andrew Lee Wilcox. Mr. Wilcox is charged on this calendar with battery count 1 and simple battery count 2. It is my understanding from the representations made by the attorney representing Mr. Wilcox, Mr. Justin Moore, that there are some issues where he's not able to come up at this time. The state wishes to put something on the record. Mr. Moore, do you waive his presence?
Your Honor, yes, ma'am. We will waive his presence, and I would give the court a little more information about his condition that might help with the determination of this case.
All right.
He's actually been in custody since I think 4/29, somewhere around that time. And then his case was accused on 6/2, I believe. I'm not sure kind of what happened there, but regardless, he's been in custody that whole time. I wasn't aware of him until actually Miss Thibodeau at the jail contacted me to ask me, say, hey, what's going on with this guy? Because I'm having a lot of trouble with him. And not personally, but he's not doing well. And so
Right.
I checked it out, and that's why I immediately contacted Mr. Tipton. My understanding is he's not doing well at all. In fact, she indicated he might be catatonic, which is quite a dangerous condition to not be in a hospital setting.
Yeah.
And so that's kind of why I'm pushing this one so hard. And thankfully, Mr. Tipton, Mr. Brooks have agreed to null pros the case on that basis. When the null pros occurs, the next step that will happen is Ms. Thibodeau intends to immediately 1013 him. We've already discussed it. And she's going to get him over to an emergency facility. He will not hit the street. And we can put that in the order in any way that might make everybody feel comfortable. I would not be comfortable doing it any other way, given his condition.
I got you.
But I guess given all the considerations, it's more appropriate to do that, I think, than to try to do the competency and all that kind of stuff. Seems this might be a little emergent for that process.
I got you. Here's the thing. So generally we don't get notice of the people coming up until they're accused. And then it goes on an arraignment calendar. So I would not have known about him since April or else I would have made sure that he was on, we were tracking his status, or he, had an appearance. So I
Of
will
course.
go. Mr. Tipton, did you want to put something on the record before I go ahead?
Yes, Your Honor. Just for clarification too, Your Honor, it was not bound over by the magistrate court until 5/28. So, and then it looks like it was not received by our office until 5/29, and it was and it looks like it was processed on 6/2. So it looks like it was received at 5/29, which is Thursday, and was accused the following Monday. So I don't know why it didn't get on sooner, but the first couple of months were it was trapped in magistrate court. Your Honor, Mr. Wilcox does not have a criminal history beyond this case. He does local. He does have an article where it says that he's a missing person. For that reason, we would ask that that he only be released to a hospital after being 1013'd. I have spoken with the victim in this case. The victim has concerns for his mental health. While she doesn't want to have contact with him, she said that this is an anomaly, and that this was the first episode that happened to the point of where she felt like she had to call the police. So,
How old is this person?
the victim or the defendant, Your Honor?
Defendant.
Your Honor, the defendant is 38 years old.
Okay.
And so Your Honor's aware they did not live together. It's not a family violence situation. It's a situation of a caretaker that came to a group home.
Okay, all right.
Mhm. And that's all from the state, Your Honor.
Okay. All right. So I am fine with whatever. So I would think that the best way to do this would be to order that he be given a immediate unsecured judicial release to allow him to leave the jail. No, wait. Well, I'm just trying to think of what's the best way so that there's a continuity of custody until such time as he's in the hospital. So
And-
is it best to allow the jail to 1013 him, and then upon his arrival at the hospital, then the case will be no prost?
And that'd be fine, Your Honor. I think it was just giving the jail the latitude to
Yeah.
take him or
Okay.
do whatever they needed to. So if you'd like,
So-
I'll be in contact with Ms. Thibodeau immediately, and then I can update everybody as soon as she tells me that he's where he needs to be, if that
Okay,
would be
so
preferable.
Mr. Yeah, if you let me know what they need, and then we'll draft the order in the way that makes it best for his continuity of care.
Yes, ma'am. And so
Okay.
I think initially she requested that he be released for that purpose.
Okay, so go ahead and do the no pros, and then they can go ahead, do a no pros, or unsecured judicial release, and then they can do what they need to do, and then no pros once he's at the hospital. Just tell me however you want it done and draft the order that way, and then I'll go ahead and sign it, because I don't want there to be a gap in what they're able to do for
No problem, Your Honor.
Okay.
I'll do that, and I'll present the order to you here in just a little bit. And then I'll update you obviously as we go to let you know when he gets there. So,
Okay, thank you so much.
yes, ma'am.
And Your Honor, I've already submitted that null pros after I saw Mr. Moore get on.
Okay, thank you. So whenever it pops up, I'll sign it.
Thank you, Your
So
Honor.
should I enter the null pros in the system or no?
Let me get the order first, and
Okay.
then I'll send it over. All right, Ms. Tortorella, did you have an announcement?
I have several, Your Honor.
Okay,
On Mr. Blankumsey,
yes,
we are going to stipulate to the violation and accept the recommendation of probation,
okay,
that one. On Miss Chastity Long's case, that would
Mhm.
be a negotiated plea. Miss Tanisha Pope's, she has 2 cases on your calendar, Your Honor, both VOPs. We're stipulating to the violation. However, we would like to leave the recommendation up to Your Honor.
okay.
And Mr. Wedlow, we're still conferencing with him.
Okay. All right, let me know when we're ready to go forward.
Okay, if you can bring Blankumsey, Solomon, Mr. Solomon Blankumsey out.
Mr. Blankumsey,
Good morning.
good morning. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand out. So Solomon Blankumsey, you're before the court on 2024 CR 09350. You were before this court for reckless driving with a plea on the 5th day of June 2025. You were sentenced to 12 months on probation. You have 10 months and 12 days remaining. You are charged, the probation department has noted that you failed to avoid injurious and vicious habits. You tested positive for the metabolites of alcohol on June 16th of 2025. You failed to complete clinical evaluation as ordered. You failed to pay your currently $225 in arrears. So, Mr. Plumcumsey, what's going on, sir?
And Your Honor, if I may, on the failure to avoid injurious and vicious habits, he started probation on around June 5th of 2025, and he was first tested on June 16th of 2025. So just on my client's, for my client's defense, Your Honor, I don't think this was enough time to let whatever was in the system out for testing.
It's
And I'm-
alcohol, not drugs. So yeah, that amount of time is like 9 days. No, that he wouldn't still have alcohol. Not enough to make a difference in his system. So, Mr. Blankumsey, you got a reckless, which probably should have been a DUI. I'm just gonna be honest with you. And so the problem is, I think that there's a failure to recognize that you have a problem with alcohol.
Not really.
I knew it. See, whenever I say that, the first thing somebody who's in denial says is not really. But let me tell you why I think so. You're in a red jumpsuit. You're in jail. This is the second time you've been here for alcohol because you got arrested for a DUI that became a reckless. But now you're before the court because I told you very distinctly and very clearly that you're to have no alcohol or illicit drugs during the course of your probation, and you'd be screened for randomly for alcohol and drugs. And then you show up with alcohol in your system. Now, if somebody told me don't drink or you're going to go to jail, I think I'd be able to manage that. But if you have a problem with alcohol, you can't manage that. And it's the people who are in denial that cause the biggest problems, because you would be the same person who would go right out and go back to drinking, and then possibly end up drinking and driving and hurting somebody, yourself or someone else. So, sir, when I say you have a problem with alcohol, everybody thinks that means you're falling down drunk, sitting with a bottle in a paper bag in front of a step. No, sir. What I mean is you're doing stuff that you would not normally do. You wouldn't normally spend time in the Clayton County Jail. Is that your preference?
No, Your Honor.
All right, but because of alcohol, you're here. You wouldn't have normally spent time in the Clayton County Jail on your arrest, but because of alcohol, you did. You're losing time, you're losing money. Do you have a job?
Yes, I do.
Would you normally spend this amount of time from your job?
Or would not.
Okay, so if you can't control your circumstances such to the point where you're doing stuff that you wouldn't do by choice, then you have a problem with alcohol. And if you can keep denying it, it's just gonna keep taking you down.
Your Honor, if I may.
No, Ms. Tortorella, this one is between me and him. Because knowing and understanding that you have a problem with alcohol is not a criminal offense. What it is a recognition that you need to make some changes in your life, or your life is going to continue down this path. Like I said, if somebody told me you're going to end up in jail if you drink, and then you drank, I always expect people who have a problem with alcohol, I always expect that once they go on probation, that first test, somewhere around that first month or two, they're going to test positive because they can't control it. And you've proven what I have observed over the course of being on this bench for 10 years.
And Your Honor, my client would like to speak.
Sure, I want to hear from him.
Your Honor, I did not have a drink. Oh, go ahead.
You didn't. You did. You were in jail, which would have been enough time for you to detox. Then you were put on probation, and that was June 5th. Then you came back on June 16th, and you tested positive in a urine test for alcohol. So now tell me how the alcohol got in your system.
Your Honor, if I may, he didn't come back on June 16th. He was actually arrested on July 14th for this. So the testing happened before that date. The results came back on June 16th. So that's why I'm again advocating for my client, saying that it wouldn't have been enough time from the date of the start of his probation on June 5th of this year to the.
Do you have his date of testing?
Excuse me, Your Honor.
Okay, so the difference is, though, Ms. Tortorella, you're telling me he was drinking on June 5th when I sentenced him.
No, I'm not saying that.
You're advocating for him, but it's not making sense. And I'm gonna just tell you why. Because you're already before the court on a reckless. If I sentence you on June 5th and you say, Judge, if he tested positive on the 16th, or that's when the test came back, he didn't have enough time to get the alcohol out of his system. So at some point within the time frame that you were before me taking the plea, you were drinking. Ms. Chang, when did the test take place?
Your Honor, the test was done on June 16th. I've sent a copy of the results via email to Your Honor.
Rello, I get that you're being a zealous advocate, but at some point, sometimes the people need to take responsibility. Because if Mr. Bluncomsey does not get that he has a problem with alcohol, we're going to be right back here.
And Your Honor, I did misspeak. He was incarcerated on July 14th. So I was thinking June 14th. My apologies to the court.
No, that's just when I signed the order, the arrest order, and he came in on my arrest order. But yeah, Mr. Bluncomsey, we can do this all day, every day. But I tell you, I've been doing this for 10 years on this court with the same set of circumstances. I get it. I can almost tell you what you're going to do next. So what I'm saying to you is when you sit there and you tell me you don't think you have a problem with alcohol, but I sentenced you on June 5th and I say don't have any alcohol, and then you come back and test positive for it on June 16th, there is nothing you can say. I have heard it all. It was in the vodka sauce. I had vodka sauce on my pasta. No. I was mouthwash. No. I took medicine with alcohol in it. No, I'm not buying any of those. So you're telling me you didn't drink, but somehow alcohol on the 16th of June ended up in your urine. So what you think happened? And let me just tell you, probation has way too many probation people to supervise to where they're not going to try and make you test positive for alcohol because that's just more for them to do. So they have no incentive for you to test positive. They don't get no extra money for it or anything. So now, be honest with me. Be honest with yourself.
Yes, Your Honor, he will be.
Go ahead, Mr. Blancomsi. See, I'm trying to save you this conversation for the next time you test positive. I got a girl right now in jail. This will be what, her second or third time before me testing positive for not only alcohol, but alcohol and cocaine.
Ooh.
Yeah.
Okay.
People who can't control themselves can't control themselves. Maybe cocaine is not your drug of choice, but alcohol sure is.
It's yours, Your Honor.
I said maybe cocaine is not your drug of choice, but alcohol sure is. You heard me. Mr. Blancomsi, the one thing I want you to get over is this feeling that if you have a problem with alcohol, there's something shameful about it. What I want you to understand is sometimes people have issues that have nothing to do with your desire to be different. If you had high blood pressure or diabetes and you didn't pay attention to it or treat it on a daily basis, then it would take you out of here. There are hardcore drug deal users who've admittedly, like rock and rollers, hardcore rock and rollers, and they still rocking and rolling. But alcoholics takes you right out. So it's a different way it affects the body. So when I say these things to you, I'm not trying to embarrass you. What I'm trying to do is make you understand that lying to me doesn't get you anywhere, but lying to yourself is just going to get you back in this situation repeatedly. We clear?
Yes, ma'am.
I mean, you're going to have some time to think about it. I just say, if you think about it and get started on what it takes to get better, it works faster than if you keep resisting it and thinking that you don't have a problem, but yet here you are in a red jumpsuit. What's the recommendation, Ms. Chang? Mr. Austin? Oh, Ms. Chang, you're muted.
Excuse me, Your Honor.
No problem.
The recommendation is that 8 days be revoked, credit for time served, return to probation, complete the evaluation by August the 2nd, disclosing the positive drug screen results to the evaluator.
All right. Is
and
he
if-
doing a community support?
I didn't share that with the attorney, but yes, we can recommend that as well, Your Honor.
Yeah, he needs some.
That he and with regard to the drug test, Your Honor, it was collected on June the 16th, which was 11 days from his sentence date. For alcohol to stay in the system, to test positive, it would be like 2 to 3 days. And the results are over nanograms, way above the cutoff level. So,
Your Honor, may the state be heard?
Hold on, Mr. Tempton. Mr. Blancomsi, alcohol and finding out if alcohol is in your body is purely scientific. It's not even a guess. It's going to be a certain amount of time that it takes to metabolize in your body. And that may vary slightly from time to time and place because of, how tall you are, how big you are, that kind of thing. But if you're testing that high and you're a big dude, that means that you had a drink fairly close to you getting to the probation office. And so what I want you to understand is you can fool yourself, but you can't. I'm not saying the same day, but I'm saying somewhere in that period of time, you had enough alcohol to where it's concerning. So, what I say, I can look at your lips and tell you drink.
Okay.
That whole light part right here, I see it. I have two uncles who were alcoholics. Both of them got taken out by alcoholism. One of them got esophageal cancer. That's what alcoholics get because that alcohol is bad on the esophagus. And the other one died from undiagnosed or untreated high blood pressure and diabetes. So both of which were not made better by alcoholism. And when I tell you both of them were my favorites, like beautiful, amazing people. So having a problem with alcohol does not make you less of a person. You got me? All right. So Mr. Tipton?
Your Honor, I would ask that Mr. C be required to weekly in addition to two community support groups two community support meetings a week.
What was that again, Mr. Tipton?
I think he said test at each report. Is that what you were asking?
That's twice weekly, Your Honor. And then because if he's off the charts, like Ms. Chang is saying, I think it may be necessary to test quite frequently. And I think two community support group meetings a week would make sense. And I would ask that the two tests weekly be for the next 5 weeks.
Your Honor, if I may, I think that with the additional AA community support group requirement, in addition to him not having any drugs or alcohol and the testing requirement initially mandated by probation, I think that's sufficient for my client. He actually lives in Gwinnett County, so I do not want to set him up for failure. Is there an alternative for him to test within his county and then send it to probation? Because he lives all the way up there and it's difficult for him to come down. And with all these random testings and requirements, Your Honor, I do feel that that the state wants to add on. I think that's a little too punitive.
This is what probation is. It is punitive. Mr. Blancomsi, I'm comfortable with test at each report and one community support meeting per week. And the reason I'm saying that is because I feel like you're going to be back. And I'm going to have some leeway to either revoke you or go up. So, because you're still in denial. Like you're looking at me and you're listening to what I'm saying, but you still don't believe what I'm saying. Which usually means when that happens that you're going to test positive again. Yeah. So, but yeah, I hope for your sake that you get it, that you don't let shame and denial keep you from being healthy. So,
Is there a way that he can test in a facility near Gwinnett County?
no, I'm going to have him test at each report to Clayton County. So he doesn't have to go to a specific facility and whenever he reports for his probation reports here in Clayton County, he's going to test.
So when we make the meetings in. What about my office? What window I come in? 'Cause I hear
What do you do for a living, sir?
I deliver food for farmers and fishers to like different restaurants and stuff.
You drive?
Yes, ma'am. I try. Sober, none drinking. Very sober.
All right, so, sir, I'm going to revoke 8 days, and after service of 8 days, you're gonna return to probation to complete all special conditions of probation and the additional special conditions of testing for alcohol and drugs at each report, an alcohol or drug cessation community support group meeting once per week. Defendant should also complete a substance abuse evaluation on or before August 2nd, 2025, and disclose his positive alcohol test of 6/16/2025. I'm sorry.
He had a question about his evaluation, Your Honor.
So take take my alcohol evaluation before August 2nd.
Yes,
AA meeting classes, when
yes.
when that's supposed to start, like, as soon as possible.
Miss Chang, did you have a date for him to meet with you?
Yes, Your Honor. This Thursday, July 24th at 10:30 a.m.
Okay, you got that?
So I haven't
And
seen I'm sorry.
Your Honor, just to let the court know, sometimes it takes the jail a couple of days to release people. They're not released on the same day. If the court can take that under consideration, and probation as well for his next probation meeting.
Well, Miss Chang, can you see when he gets to, like, can you look in the computer and see when he's released?
Yes, Your Honor.
Okay, so if he doesn't show up, if he's still in the jail, then she will be able to see that. Otherwise, there's no excuse.
So what is he supposed to do when he's released? Report to Ms. Chang immediately? Like
If
With
he's,
it-
if he's not-
yeah.
Okay.
Miss Chang, go ahead.
I was just going to say within 24 hours, Your Honor. He- If he's still in jail July 24th at 10:30, then he's to report within 24 hours of his release.
Thank you.
So when you're not
All right, you can go back with the sheriff's office, sir. I sent over the order.
Thank you, Your Honor.
You're welcome. All right, who's next?
And Your Honor, the deputy's getting Miss Chastity Long.
Okay.
You just did Solomon. So we just got Long, Pope, and Wedllo left. I think, right? Yeah.
All right, Miss Long, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true. I'm sorry, speak up. All right, you can put your hand down. One second. Did not see her petition. Uh,
Your Honor, Miss Long's a plea, not a petition.
Oh, okay. I'm sorry. For some reason, oh, good point. I don't know why I was thinking petition. That must be Pope. All right, so Ms. Long, you're before the court on State of Georgia versus Chastity Lucilla Long, 2019 CR 07229 for simple battery, family violence, and simple battery. All right, so Ms. Long, you're represented by attorney MJ Tortorello, who's with you at the podium. Ms. Tortorello, what does she plead to the offenses before the court?
Yes, Your Honor, for simple battery, family violence, the count 1, that will be a guilty plea. For count 2, simple battery, that will merge into count 1.
All right. By internal plea of guilty to count 1, simple battery, family violence, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am? All right, factual basis and recommendation, please.
Yes, Your Honor. On August 1st of 2019, officers with the Clayton County Police Department were called out to 4124 East Tanner Road in Ellenwood, Georgia, here in Clayton County. There they met with the complainant, Mr. Kerry, that's Kerry Long, common spelling, who stated that his wife arrived at the location and began to strike him in the face and chest. It was determined that Miss Chastity did strike Mr. Kerry Long with her bare hand in the face and chest. This was observed by a security guard on the scene. Your Honor, state's recommendation is 12 months to serve 23 days, credit for time served, continue with mental health treatment, provide probation with a HIPAA waiver, and have no contact directly or indirectly with Mr. Kerry Long. And that's no contact through third persons, no contact through media, social or otherwise, with the exception of their pending legal matters, which include from what I understand, they're in the process of divorce.
All right. Ms. Tortorello?
Yes, Your Honor. As far as probation, we're requesting that fees can be waived, and also if she could do virtual reporting. She does live in Columbia, South Carolina. She does not live in the state.
State does not object to virtual reporting.
Is that a thing, Ms. Chang? Ms. Chang?
I'm sorry, Your Honor.
Is there such a thing as virtual reporting?
To probation
Yes,
or
ma'am.
no, Your Honor.
Your Honor, if the defense is asking about phone in reporting, state has no objection.
Okay.
Phone reporting.
All right. So, Ms. Long, I'm going to accept your plea of guilty. On count 1, count 2 will merge. I'll send you to 12 months to serve 23 days. Balance will be probated. You can report by phone and mail. The court will suspend your supervision fees. You're to continue your medication management and under your position, you're to provide the probation office with a HIPAA waiver that allows them to have access to certain information to monitor your compliance. You're to have no contact with Kerry, Kerry Long, with the exception of any requirements for court attendance or court process through the process of divorce, child custody, visitation, or any of those things that are being handled by the Superior Court. Did I miss anything, Mr. Tipton?
No, Your Honor, you did not.
All right. So, Ms. Long, the intake professional, Ms. James, is going to come see you and get you signed up for probation. Ask any questions that you have about phone and mail report. The easiest way is to report by mail because they have a whole ton of people that they supervise and they can't always get to everybody's phone call. So, as I tell people, if you get 12 envelopes and 12 copies of the form, and you have those envelopes pre-addressed and pre-stamped, then all you have to do is fill out the form and drop it at a post office. Do you understand? The quickest way to get rearrested is to not report to probation as directed. Do you understand that?
Yes, ma'am.
You have a question?
Yeah, I thought it was the time served for the 15 days since I've been here since the 7th. And you said 23 days.
Yeah, you,
She's been incarcerated previous to to her present period of incarceration on the same charge. I believe she was picked up on a bench warrant. The total is 23 days and it is credit for time served between her 2 times in jail.
Okay. So I'll give her that credit for time served.
Oh, okay.
All right. So you can go back with the sheriff's office, ma'am.
Thank you.
thank you, Your Honor.
All right. So who's next?
The next, can you, Miss Tanisha Pope.
All right. Ms. Pope,
Yes, ma'am.
raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I swear.
All right, you can put your hand down. So Ms. Pope, you're before the court on 2 cases for probation revocation. State of Georgia versus Tanisha LaShawn Pope, 2021 CR 07991 and 2023 CR 02968. You were before this court for driving under the influence and theft by shoplifting on the 17th day of September 2024. You were sentenced to 24 months on probation. And you have 1 month and 21 days on the 2021 CR 07991 probation, followed by 12 months on consecutive case 2023 CR 02968. It says that you failed to report to court. You were scheduled to be in court on April 21st, 2025 for a revocation hearing. You failed to report. You failed to report to probation on November 15th, February 15th, November 15th, 2024, February 15th, 2025, March 15th, 2025, and April 2nd, 2025. You last reported by phone on March 3rd of 2025. You failed to document your proof of completing a clinical evaluation as directed. You failed to document proof of completing a DUI, alcohol, or drug use risk reduction program. You failed to attend AA or NA community support meetings at least 2 times per week. You failed to comply with a drug screen at each report. You failed to document proof. You failed to complete and document proof of completing 40 hours of community service on case 2021 CR 07991. And you are currently $810 in arrears. You're represented by Attorney MJ Tortorello.
Your Honor, we are here to stipulate to the violations alleged by the probation, and we would like to leave the recommendation up to you as previously noted before this court. I do want to address that my client, just to give a little bit of background about what's going on with her, and then I want to also address some of the violations here being alleged. She is currently, she has an ectopic pregnancy, and it's life-threatening, as you know, Your Honor. She had a surgery, emergency surgery scheduled on July 21st, which was yesterday. Probation has received documentation of proof of this, Your Honor. So it's important for the court to know my client health at this point in time. It's a life-threatening situation. She has 4 children, Your Honor, that she needs to get home to and take care of. And probation is asking for 120 days on this, Your Honor. And just given what's going on with her health-wise, I don't think it's reasonable. Also, Your Honor, for failure to report on February 15th of 2025, my client had surgery on Valentine's Day on February 14th of 2025, and proof has been provided to probation by her brother yesterday. She also lives in Americus, Georgia, Your Honor. It's a rural area, and she doesn't have the closest AA or community support group that she can go to is 3 hours away, Your Honor. Given all this, we're asking for a lot less time than 120 days for the revocation.
Your Honor, may the state have a moment to review her sentences and be heard?
Sober.com, Americus, Georgia, at 702 Atherton Street, has a AA meeting. The weekly meeting schedule is Friday, 8 p.m. to 9 p.m., Tuesday, 8 p.m. to 9 p.m., Thursday, 8 p.m. to 9 p.m. There's a Flint River group in Montezuma. There, yeah, ma'am. Yeah, there's AA in right downtown in Americus, all between Lafayette Street and Atherton Street, right across from the Gas and Go. So, you know, let's see. Here's another one. Yeah, this group at the one on Atherton Street, yeah, they have several meetings. Lots and lots of meetings. So Ms. Pope, what you got next? How old are you, Ms. Pope?
I'm 37.
Ms. Pope, when are you gonna start helping yourself?
I've been trying, Your Honor.
If you come to court and tell me there's no community support meetings in Americas, and then I look on my tablet and I pull one right up, then you're not helping yourself.
I had Googled it, and when I called, they told me they didn't do that anymore, and they had one out of town, like in Albany, Georgia. And I was trying to get transportation to get to Albany to do the AA meeting. I promise, Your Honor, I've been trying. Like, I'm so sick. Like, this pregnancy in my tube is like, and they're not helping me in here. Like, I'm bleeding so bad. I'm hurting so bad. Nobody's taking me to medical. Like,
I got you, Ms. Pope, but Ms. Pope, at this point, I get the pregnancy, and we're gonna get you medical help because you need help. But what I'm telling you too is you need to start thinking about the fact that maybe another baby is not what you need at this time of your life.
I wasn't trying to get pregnant, y'all.
Okay. Yeah. What's the recommendation is 120 days?
Yes, Your Honor. 120 days, that would be the 1 month and 21 days remaining on there, and 69 the consecutive case. And I have not received, as of prior, to starting court this morning, I checked for documentation because I spoke with Ms. Pope's brother yesterday, and I asked him to send that to me via fax. But prior to court, I checked, and I have not received any documentation.
Of
If
documentation of what, Mr. Chang?
Well, Ms. Tortorella said that probation has received documentation about surgery or medical documentation. I haven't received that.
Your Honor, I was told by my client that her brother sent it over yesterday to probation.
Last night when I got out of lockdown, I talked to him. He said she told him to send it before the morning. And he sent it.
I can check again, Your Honor, right now to see if there's anything there. If I may step away.
His number and you can call him. Because he said you called him back yesterday.
Okay, how is this part, the ectopic part of the pregnancy been documented?
You talking to me, Your Honor?
I mean, whoever wants to answer.
I went through my OBGYN and
Have they sent us something?
They sent, the thing for me to do my surgery, the laparoscopic surgery. They sent it through, email for my follow-up appointment. And my brother said he sent it to Probation Officer Chain.
Ms. Pope, you have 24 months with me. Very rarely do I sentence anybody consecutively. You got a lot going on, and you're going to have to at some point make a choice to get your life together, because everything is not, you're pregnant. I didn't mean to be pregnant. Well, they got ways to not be pregnant, ma'am. And I'm not saying that I'm trying to control your intimate life. I really don't care. But you already got 4 kids. You got a case where you're on probation for 24 months before me. You live in Americas. That's not right around the corner from here. You have got to start taking control of your life. You tell me, well, I can't get to AA, but my understanding is that since COVID, they've had virtual community support meetings. So even if you don't want to have one in your town, they have them on the internet that you can get to. And you're saying that you couldn't find that at all.
That's what I was asking Miss Chain, like, do they have virtual? Because I could do virtual. And then I had surgery on my hand from it being broken. But I have done my DUI risk reduction program. I am trying, Your Honor. I just had hand surgery. I just got out of my cast. I had a cast on for 5 months. Like,
are you working?
No, well, I was braiding hair, but my hand was.
Okay. Do you
That's
have
my-
another source of income?
Ma'am,
Do you have another job that you're prepared to be doing?
no, I just braid hair and I get child support for the kids. I'm a single parent. Like I know I'm trying, like I raised my kids alone, me and my mom. My son just graduated high school. He starts college in August. Like I'm trying, Your Honor.
I got that. But in the midst of you having all of this on you, then I hear about another pregnancy. Miss Pope, if you don't take care of yourself, who's going to? If you don't protect your health, who's going to? Babies don't just happen. And I'm not saying stop having intimate relations. That's not my job. But what I'm saying is stop making your life harder. If you know you don't have a job, if you know you have significant health issues that are keeping you from working, if you know you got 4 other kids, a slip up is not what you can afford. If you know you on probation before me for 24 months, at some point you have got to say, I gotta make a list of the things that I need to get done and figure out how to get them done.
Yes, ma'am.
You understand?
Yes, ma'am.
So when you had the surgery back in February and you missed court, you're saying, I wanted my brother to send that information. Why didn't you send it?
No, my brother did. My brother just sent it yesterday. He didn't. He wasn't
What
aware.
I'm saying to you is back then, you know, if you're missing probation check-ins, that you got to have a reason for that. Why didn't you send it or have the doctor send it directly to Ms. Chang?
Right, Miss Chang gave me an address to mail, like doing a mail-in report. I sent paperwork to her. I don't know if that's the correct address because they never. They could. And she saying I'm supposed to have never received anything about court, like never. Then when she spoke to my brother yesterday, she was like she just needed an updated address. Miss Chang has my address. I gave her my address personally. My mom gave her my address. So, and then half the time she don't answer the phone. She don't return.
Ms. Pope, I just told you that she got 1,000 people that she's got to take care of. You're one person saying, I need her to respond to me. She's got 1,000 people saying, I need her to respond. So no, she's not going to answer the phone. If you're on phone and mail report, get your 12 envelopes and make sure it gets there in the mail. But what I'm saying to you is take the extra effort. If you know you've had hand surgery, then tell your doctor, hey, I need you to fax this information or send this information to my probation because I can't, I need them to know why I can't make it to report. Take some initiative, ma'am.
Yes, ma'am.
Stop letting stuff just happen to you. Start being the person that does stuff as opposed to the person that stuff gets done to. What, Ms. Chang, is this her first hearing?
Yes, Your Honor. She was served by mail, by certified mail on April 3rd of this year. And it was returned to us by the post office on May 17th as unclaimed.
So
It was sent to 206 Horton Drive, Americus, Georgia, 317.
is that your address?
That's my address, but I haven't received nothing.
So, ma'am, it is common sometimes when people don't know what's coming in the mail for a certified mail, they will not receive a sign for certified mail. What I'm telling you is she's been sending you the information to the correct address. Now, if you didn't get it, that's on you. But certified mail means they're gonna bring it to you and ask for a signature.
I have been there and I haven't.
Who else lives with you?
I live with my uncle and my kids.
Okay, so somebody didn't sign for the certified mail, but she's got your address. So that's not her responsibility, that's your responsibility. Ms. Pope, at some point, like I said, at some point, you've got to be the person who drives your life as opposed to get rolled over by the truck. How is she reporting, Miss Chang? Is it by mail, phone and mail?
She was to report by mail, Your Honor, because of the distance.
And how
she
had
lives
she been
up-
doing with that?
she was not, Your Honor. She was to report by mail by the 15th of each month, and those are the dates that she missed: November 15th, February 15th,
Ms.
March
Pope, they don't have a
15th. Those were
post office in Americas?
Who, ma'am?
A post office.
Yes, ma'am.
Okay, so why couldn't you drop your envelope in the mail so that Ms. Chang could get your report every month?
Like I said, I mailed one of them in, but after I had surgery, I just been down, like, it's me by myself. My uncle works, my kids been helping me, like,
So you couldn't nobody could put a letter in an envelope for you and take it to the post office?
I try to do everything on my own, Your Honor.
How's that working for you? You got a kid who's in high school. They can't put a letter in the mail for you?
They got, it's like the one that's in the 11th grade, he got like a disability.
But you said he's about to go to college.
No, I just had one graduate high school.
And that person can't help you?
No. He lives with mama.
So you don't have 4 kids living with you?
I have four living kids, but I just let the one that just graduated high
Ms.
school.
Hope, do you understand that every time we talk, something else comes out that's different than what I understand? All you had to do was put an envelope in the mail, and now you can't do that. You can't do nothing. There are people who operate in this world who have one leg or one arm, and they get so much done that you can't even imagine. I had a friend who's blind, and he travels the world by himself. So when you tell me your hand had surgery and you can't go to the mailbox and drop an envelope in the mail, you have got to stop just not doing.
That's what I'm telling you. I did it one time. I don't know if
One time, then do it every time. I didn't tell you to report one time. I told you to report every time.
But I'm asking, am I sending it to the right address? Because they're not returning the mail to me.
I did not receive any reports from her, Your Honor.
She said she only did it one time.
Yeah.
So if she did it one time, but she's got 3 or 4 times that she didn't do it, how would you know?
Because I spoke to her over the phone, and then back in May is when I sent that mail in, but I never received nothing back in the mail.
What you think she's supposed to do? When you send in your report, she's supposed to call you and say, hey, I got it. Is that what you're looking for? That's not going to happen. But if you don't send it in, an arrest warrant is going to come across my desk and I'm going to sign it. And that's why you're in jail. Ms. Pope, get your life. Get your life. You are making so many excuses. Then all you're doing is showing your kids that you just make excuses through life. Excuse after excuse after excuse after excuse. You telling me that you had surgery, so you can't make it to mail an envelope to the post office. But there are people who are missing whole arms and legs who can navigate life. Get it together. You saying you can't do anything but braid, but there's other jobs that don't require you to have the dexterity to like that braiding hair requires. Look
And
for that.
I also told Officer Chain that I was doing like a private, what you call it, like when you sit with the elderly people, but I stopped that job because my client passed away.
And there's no other people who are elderly or sick?
No, I was doing it privately through this lady that I know because she's known me so long. And she just didn't want to be with her mom.
Ms. Pope? Ms. Pope, you got 12 more months, 13 more months to be with me. You understand that, right?
Yes, ma'am.
This is your first hearing, so I'm not gonna put you in jail for 120 days because we honestly, the county can't afford to pay for your surgery. So whatever you're gonna do with the ectopic pregnancy and the surgery, go ahead and get that done. I'm gonna give you
Your
credit
Honor,
for.
may the state be heard?
Hold on, Mr. Tipton. We're not signing up for that. I'm gonna give you credit for time served, since lockup. You're gonna return to probation. You're gonna do mail-in reports. You're gonna do, one community, report each. And if you have to keep checking, have somebody check for you, find a virtual program or go to the one in Americas or go to the one at the next town over. I don't care, but you're gonna have to start going.
Question.
I'm sorry.
May I ask you a question?
Yes, ma'am.
Like for my community service, like since I joined church, can I do like
No,
community
ma'am.
at churches?
No.
Oh, okay.
They have agencies in Americas. Americas is a big enough town to where they have nonprofits where you could do service at a nonprofit.
I think I'm gonna go with Salvation Army.
Yes, fine. Get it done, Ms. Pope, and stop making excuses.
Thank you, Your Honor.
Everything in your life is an excuse. Well, you know, Ms. Pope, this is a calculated risk because I anticipate that I'm gonna see you again. Because you're not gonna do right. I'm just telling you. I already know. I've been doing this too long. You have already told me that you will not do right. And because I have 13 more months with you, I know that I will get another chance to put you in jail. For that, I have no doubt. So right now, because I'm not about to pay or have the county pay for this surgery and your convalescence, then I'm gonna let you out, let you get that done through whatever you already have set up. Now, Mr. Tipton, go ahead.
Your Honor, I just want to bring it to the court's attention and I wanted to ask Ms. Chang as well. So Ms. Chang, it wasn't clear from your petition, but has Ms. Pope ever tested for drugs? Because it looks based on the petition, I can't tell if she has ever been tested for drugs.
She has not.
Okay, so she's missed every testing of for drugs during the entire 10 plus months?
Because of the distance, she was given different dates to get a test in her area at a lab in her area and submit proof to me as opposed to coming to our office for testing. And
Oh,
she
boy.
never documented any test results.
Ms. Tortorello, I'm at a loss because your client's not doing anything she's been ordered to do. Not one thing. I don't even know that she's having an ectopic pregnancy because we don't have any proof.
Your Honor, she's done the risk reduction class. She's reported
One time.
one time. You know, she's trying, she's had a lot of health issues, Your Honor. And I mean, we could all give a phone call to the jail to just, you know, verify that in fact, if she has an ectopic pregnancy, which I'm confident that my client is being honest with the court, Your Honor. If you could just give her a second chance. I understand that probation has to be punitive. If it's punitive to impossible, it's setting up people for failure in the system. And I'm just asking this honorable court if they could please give my client a second chance, and she will abide by everything that she has to do. She's had a conversation with you, Your Honor. She is clear about what she has to do to make this happen.
Ms. Pope, Ms. Tortorello is more passionate about your situation than you are. She believes in you more than I do. And maybe more than you believe in yourself. Because I just don't understand why you got phone and mail report. All you had to do was drop a letter in an envelope in the mail and you can't get that taken care of. Ms. Chang says, go get tested at the local lab. Every place got a LabCorp or one of those local labs. She says, go get tested at the local lab. You can't get that done. and produce there's nothing, you're not doing it. And the reason we gave you phone and mail report is because you live far away, and I was respecting that. But I don't have to do that. I don't. None of these accommodations that we've made for you do I have to do. None of them. What do you do all day?
Ma'am,
What are you doing all day?
I just take care of my kids, send them to school, but.
Okay,
like,
one of them doesn't even live with you. What are you doing all day?
Ma'am,
I said, one of them doesn't even live with you. What are you doing all day? And
I-
they're all in school. So what are you doing? Because they're going to school.
it's like, it's hard with my 11th grader that his daddy is dead. I'm raising him alone. He's special need. Like, he needs more attention than, you know what I'm saying?
Does he go to school?
Yes, ma'am.
Okay, so how long does he go to school?
Make sure he goes to school.
Okay, so if he's in school, then that's some time you don't have to do anything for him. He's in school.
When they're in school, I still have to, when my uncle's at work, I still have to make sure they have food. You know what I'm saying? I do this alone. I get assistance from the system, you know.
Ms. Pope, I'm not asking you that. I'm asking you, what are you doing?
Right. I do stuff at home. I'm a homemaker. Like, I do everything at home. Your Honor, please just give me a second chance. And like I said, when I had my surgery, that's why I wasn't able to do my mailing. I meant the drug test, because they said it's 25 to 50.
No, ma'am. No, ma'am. No. I'm sorry.
Your Honor, I would like to get a little more clarification on this petition from the probation officer, if I may.
Sure.
Officer Chang, I want to make sure I understand briefly. She's missed February 15th, March 15th, April 2nd, and March 3rd. Is that correct?
March 3rd is when she last reported by phone, which I called her that day.
Okay,
So whenever she missed her mail-in reports, I would call her, but I counted that as a phone report. We went over the case.
okay, so 4 out of 10. So that's 4 out of 10 months worth of meetings she missed. 4 out of 10 reports she missed. I'm sorry, 4 out of 9 because she was incarcerated during the last one, or during the 15th last month.
She was in jail. She was released on this case on September 17th of last year, but she remained incarcerated until October 25th on a Superior Court case. So,
okay.
And then her first report by phone was on October the 30th, and she was instructed to report by mail monthly by the 15th, with her next report being November 15th. So she missed November 15th. I called on January the 6th, and we did a phone report that day. So that's why I didn't count a failure to report January 15th, because we spoke January the 6th. She was instructed to report by mail by February the 15th, and she missed that date.
Okay.
So, and so on.
So
Okay.
Okay. So
Miss,
that's
until I can get medical documentation of the ectopic pregnancy and the planned surgery, Miss, she's staying in jail. So I'll reconsider her getting out. Yeah, but until I get documentation of her surgery, she's gonna stay in jail. We'll just continue this hearing.
Your Honor, I thought you already made your ruling on the record.
I'm sorry,
I thought you already made.
I didn't write it. And I am free to reconsider.
Yes, Your Honor.
All right, so this hearing will be continued until next Tuesday or until such time as I get documentation from a healthcare provider that she has the medical condition that we talked about and is in need of emergent care.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor. That's all I have, Your Honor. May I be excused?
Yes, Ms. Chang.
Thank you.
So Ms. Pope will be continued until next Tuesday, Ms. Val.
Your Honor, would it be possible, since she may have a medical condition, would it be possible to, I'm not even going to ask Your Honor. Your Honor's already made your ruling.
If I get medical documentation, I don't care where it comes from, as long as it's a certified medical provider. All right, Wedlow, what we doing?
So Judge, Mr. Wedlow, based on our conversation, we're going to have to ask for a hearing, although I think I just have to ask for a hearing, Judge. I mean, he wanted.
Okay, when do we want the hearing?
Yeah, I mean, he kind of wanted to hear it from you, that hearing or a stipulation, but at this point, I think.
He wanted to hear from me what now?
Well, he wasn't satisfied with my my advice that he essentially can resolve it through a stipulation or have a hearing if he wants to contest it. But I've told him that, Judge, and so I'm just asking to be set down for a hearing if the court wishes.
Okay, is the probation department ready for a hearing, or do you need time?
Your Honor, we can move forward today.
And so that's fine. Just make sure Mr. Austin is aware he is contesting the allegations of criminal conduct. And, I believe that, I'm not sure if the state would, or the probation office needs witnesses for that, but we can go forward. If the probation office is ready.
I'm ready to move forward today, Your Honor, if you want.
All right, let's bring him up. Mr. Wedlow, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. Mr. Taj Wedlow, you're before the court on case 2024 CR 06670, case 2024 CR 06671, case 2025 CR 00261, State of Georgia versus Taj Wedlow, petition for revocation of probation. You were before this court, you entered pleas on battery, family violence, simple battery, family violence, violation of a family violence order on the 23rd day of June 2025. You were sentenced to 12 months on probation. You have 8 months and 3 days remaining on probation. It says that you violated the law by being arrested on July 11th, 2025 for criminal trespass and obstruction of an officer in Clayton County. You failed to provide proof of completing an anger management program, and you're $100 in arrears. Mr. Lynch?
So Judge, at this point, he is not stipulating to any of the violations. And so we requested an evidentiary hearing at which my understanding is we're proceeding at this point. I guess I'm waiting to hear what evidence is going to be presented to this court.
All right. Mr. Austin?
Your Honor, I've this order on July 10th of 2025, stating that he was arrested by Riverdale police for the
Hold on a second.
offense.
I'm gonna object to hearsay. If Mr. Austin is gonna go into what's been reported to him, I understand that there's a petition, but it's, maybe I jumped the gun here, but sounded like he said something about what was reported to him.
All right, listen, since y'all are demanding an evidentiary hearing, we're gonna call people in. So this case will be continued for 2 weeks for the probation office and the state to subpoena witnesses.
Copy, Your Honor.
All right, thank you. All right, I believe that is the last thing we have. Thank you all.
Can I speak, Your Honor?